We're going to talk about the Constitution as the foundation of the legal environment. There are two conflicting theories on interpreting the Constitution. The bedrock view is the strict constructionalist or originalist view. The purpose of the Constitution under the bedrock view is to state fundamental principles for all times. This is not the majority view or the view that is used in interpreting the Constitution at this point. Instead, it's the living document view. The living document view is a more flexible view. It sees the Constitution as a statement of goals and objectives, which is intended to change with time. There are three ways that the Constitution is amended or has been amended by practice. It used to be that the president had to get the approval of the Congress for the treaties. Instead, though, George Washington, by practice, negotiated treaties and then got approval thereafter. So it was the practice was amended, or it was amended by practice, the way that treaties are approved. The constitutional amendments, we have 27 constitutional amendments. The most common way or predominant way of amending the Constitution is by judicial interpretation, or when the Supreme Court interprets the Constitution. The living document view, as a result of the living document view, we have a strong federal government and a strong president. And the states don't have as much power as was interpreted, or the federal government was supposed to only have the delegated powers. However, because of the living constitutional living document view, the federal government and president have a lot more powers than what's actually stated in the Constitution. Also, we have administrative agencies, and these administrative agencies like the EEOC or the FDA, they're actually considered to be the fourth branch of government, even though they're not stated in the Constitution, and they make a lot of laws, or are a significant source of law. In fact, if you remember, when we were talking about the nature of law, one source of law comes from the administrative agencies, or what are called administrative regulations. The Commerce Clause gives Congress the power to regulate commerce between foreign nations and also between states. So the Commerce Clause gives the federal government the ability to regulate any commerce or business between the states. So that gives Congress more power, or the federal government more power than what's stated, obviously, in the Constitution. States also cannot make laws that burden interstate commerce. The Constitution establishes individual liberties and also limitations of those powers. That's one thing. The Constitution sets up the structure of the government. For example, we have the judicial branch, which interprets the laws. We have the legislative branch, which makes the laws. And then we have the executive branch, which carries out the laws. The Constitution, again, sets up the structure, which I just talked about a second ago. It also sets up the individual liberties. And so under the Constitution, there's certain rights and also limits. For example, there's the First Amendment right to freedom of speech, liberties that citizens have, and also a duty upon the government, or limitation of the government's powers. The Constitution sets up the powers of the government. There's some delegated powers. These are powers that are expressly or only federal government powers. The power to declare war, the power to print money, the power to establish an army and navy, to enter into treaties with foreign governments, to regulate commerce and trade between the states, and to establish post offices. These are purely federal government powers. Then there's certain powers that are actually shared, and those shared powers include the power to tax, the power to make roads, the power to protect the government, to create lower courts, and then also the taking private property with just compensation. Then there are certain powers that are purely powers of the state, and this can include interstate commerce, regulating intrastate commerce or commerce within the states, issuing licenses like driver's license, marriage license, establishing local governments. There's certain powers that are prohibited, which are powers that neither the state nor the federal government should do. These include ex post facto laws, which deal with criminal laws only. So an example would be that if when someone committed an act, it was not a crime, you cannot charge them with a crime. Or if they committed a crime and the penalty when they committed the crime was lower and then it has increased after they committed the crime, you cannot charge them with or you can only charge them with the penalty at the time that they committed the crime. The U.S. Constitution establishes, again, those liberties and also powers. An example is due process. The due process clause says that we are protected from the loss of life, liberty, or property without some type of hearing or some type of due process. Also, equal protection is a constitutional limitation on the government and a right that citizens have. It says that similarly situated people should be treated the same.